We're on record. We have two cases here, both State of Ohio versus Timothy J. Miller. Case number 21CR021, 21CR0039. Are you Timothy J. Miller, appearing by Zoom from the jail?
Yes, Your Honor.
And Mr. Phillips' attorney is William Arbitrout. He's appearing by Zoom from his office, and the state is being represented by Assistant Prosecutor Adam King, appearing by Zoom from his office. Now, Mr. Arbitrout, are you and your client waiving the right to be present here at the courtroom and agree to be conduct this proceeding by Zoom with remote video?
Yes, we are, Your Honor.
And you're all right with that as well, Mr. Miller?
Yes, sir.
All right, thank you. All right, now, case number 21CR21, the defendant is charged with failure to provide order or signal of a police officer. And in case number 21CR039, he's charged with failure to appear in the previous case, I believe. And that is a fourth-degree felony. The trial date was set for July 15th, originally on the 39 case, and I think 21 was also set for the 15th, and we set the matter for plea today after there had been a request for continuance. I think the new trial date was actually July 21st. All right. Mr. Miller, I've been presented with a plea of guilty form in both cases. I'll look at the 21 case first, and that is the failure to comply with the order signal police officer case. And I have a plea form here that the prosecutor's office prepared from a computer form, and I'll hold that up to the camera for you to take a look at. You recognize that first page of that agreement?
Yes, sir.
All right. On page 3, there are signature lines, and about a third of the way down or fourth of the way down, there's a sentence that reads, "I enter this plea voluntarily," and I've got that held up to the camera. And do you recognize that as your signature on this agreement?
Yes, I do, Your Honor.
All right. Then in the other case, 21CR39, I'll hold that up to you. That's the failure to appear. You see that charge there with your case number or plea form with your case number and name.
Yes, sir.
And on page 3, there's a similar page and a line that says, again, "I enter this plea voluntarily," and I'll hold that up to the camera. Is that your signature there next to my finger?
Yes, it is, Your Honor.
When did you sign these agreements, Mr. Miller?
When did I sign?
Yeah, when?
The day before yesterday.
Okay. And was Mr. Armstrong with you when you signed them?
Yes, he was.
Did he go over each of those agreements with you and explain them to you and answer any questions you might have?
Yes, he did.
And you feel you've had enough time to fully consider this matter before making this decision?
Yes, I have, Your Honor.
And did you understand that if you sign the agreement and go forward, that means that there's not going to be a trial, and that the next step in the cases would be a sentencing hearing? You understand that?
I do. Yes, I do.
And are you entering into the agreement to plead guilty to these charges voluntarily in each case?
Yes, I do, Your Honor.
Right now, the agreement in the first case, 21CR21, states that you're going to withdraw your not guilty plea, plead guilty to the charge in the indictment of failure to comply order signal police officer third-degree felony under 2921.331B of the Ohio Revised Code. Further states that you understand that the maximum penalty for that could be 36 months in prison. There's a minimum of 9 months in prison if the term of imprisonment is imposed, and there's levels in between those two. There's a maximum fine available of up to $10,000. There's a requirement that there be a suspension of your license for at least 3 years, up to a maximum of life. And if you are sentenced to prison on any other felony charge, then conviction for failure to comply is required to be served consecutively to the other sentence in any other felony case. You understand that?
Yes, I do, Your Honor.
Now, the failure to appear in 29CR39, that agreement says that you're going to withdraw your not guilty plea, plead guilty to failure to appear under 2937.99, a fourth-degree felony. States you further understand that the maximum prison term for that could be 18 months in prison if one is imposed. The minimum would be 6 months if the prison term is imposed, and the maximum fine of $5,000. You understand that?
Yes, I do, Your Honor.
You understand that if you are convicted of both of these charges, the court must impose, if I impose a sentence of prison, it has to be served consecutively to each other, so that means that you'd have a total of 18 months in this case, 36 months in the other, so that means there could be a potential prison term of up to 54 months. Do you understand that?
I do, Your Honor.
Are you facing any felony charges in any other jurisdiction?
No, I'm not, sir.
Are you currently on probation, community control, parole, or post-release control for a felony in any jurisdiction?
No, sir.
All right. Now, under the law, if you are convicted of both these offenses, let me back up. Under the law, if you're convicted of the charge in 21 CR 21 of failure to comply with order to signal a police officer, under the law, once you complete the prison term imposed by the court, it is mandatory to be put under post-release control supervision for a period of 3 years. Yeah, I had the wrong phone there. And that means that you will be supervised by a parole officer under the term set by the adult parole board. But the judge and the court has nothing to do with that. Now, in the failure to appear, post-release control supervision is optional up to 3 years. They may do it, but they're not required to if they make that decision. But in your failure to comply charge, if you're convicted of that, it is mandatory that that be served as part of the sentence. And what that means is that if you violate any of the conditions that the parole authority has imposed during that period of 3 years, they can return you to prison even though you served the entire term that was ordered by the judge, to serve an additional period of up to 9 months for one violation, but there is a cap or limit of half of whatever prison term was imposed for all violations. But if your violation is a new felony, then in addition to whatever sentence the judge in a new case will impose upon you, that judge is also authorized to sentence you in this case to an additional period of 1 year, whatever time left on that period is post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. You understand that?
I do, Your Honor.
Now, neither of these offenses are mandatory prison sentences, so under the law, I am permitted to impose community control instead of probation, instead of prison for these offenses. And community control is what we call probation now. And what that means is that instead of being sentenced to prison, you will be put under the supervision of a probation officer for a period of up to 5 years under terms set by the court. And if during that period of time, the probation department felt that you failed to comply, then they would file a written notice of that with the court, would be given an opportunity for a hearing, and if the outcome of the hearing was that you failed to comply, then at that time the court could revoke your community control and then sentence you to prison for a total of 54 months and fine you in the 2 cases, a total of $12,500. You understand that?
Yes, Your Honor.
Right now, the charge in case number 21 CR 21 states that on or about December 29, 2020 in this county, you operated a motor vehicle as defined under ORC 4501.01 so as willfully to elude or flee a police officer after receiving a visible or audible signal from a police officer to bring the person's motor vehicle to a stop, and the operation of the motor vehicle by the offender causes substantial risk of serious physical harm to persons or property. Violation section 29.1.33b, which is the failure to comply with order signal. Police officer, third degree felony, penalties I've just described. Case number 21 CR 39 alleges that on or about February 17, 2021, Highland County, Ohio, you did recklessly fail to appear as required in Highland County Police Court case number 21 CR 0021 after having been released pursuant to ORC 2937.29 and released in connection with the charge of commission of the felony. That would be a violation of section 2937.99 of the revised code, also a fourth degree felony with the penalties that I've just described. Mr. Miller, do you understand what it is you've been charged with in each of those cases, what the state said you did, when or how they alleged that you did it?
Yes, I do, Your Honor.
And have you discussed the nature of the charge in each case, the evidence that applies to each case, possible offenses you might try to raise in each case, possible legal issues to be involved in each case, and possible outcomes of the trial in each case with your attorney?
Yes, I have, Your Honor.
And are you satisfied with his advice and confidence in this matter?
I am, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to get you to plead guilty here today?
No, sir.
Now, on each of these plea forms, there is on page 2 some sentences that are typed in bold and underlined, and then on the 21 case, it has some additional language added with ink. I'll hold that up there, see for you to see. You see where they've added in the language about the restitution? I know your attorney talked with you about it right before we started.
Yes, I do, Your Honor.
All right. Oh, and by the way, I forgot to tell you at the beginning, if you at any time want to talk to your attorney and ask him any questions, or if you have anything that you would like to know before we go any further, just let me know. I can put you and he into a breakout room where he can talk to you privately and no one else will be able to hear you or see you and it won't record you. You understand?
Yes, I'm fine.
Okay, well, if anything comes up, just tell me.
Okay.
Now, the agreement that I just showed you in the 21 CR 21 case reads, defendant shall enter plead guilty to the indictment, state defense jointly recommend 24 months incarceration consecutive to 21 CR 0039. State will not impose judicial release after 6 months. That's printed in bold and then added to that in ink. Defendant agrees to make restitution to Greenfield Police Department amount of $879. Now, is that your understanding of the agreement?
Yes, it is, Your Honor.
Does anyone promise you anything other than that to get you to plead guilty here today?
No, sir.
Now, in the other case, we're going to see our 39. I'll hold that up to you. You see that language there?
Yes, Your Honor.
All right, the underlined and bold portion of that page 2 reads, defendant shall enter and plead guilty to the indictment, state and defense jointly recommend 12 months, consecutive to 21 CR 0021. State will not oppose judicial release after 6 months. Now, is that your understanding of the agreement in that case?
Yes, sir.
And you understand that the total then that they're recommending would be 36 months.
Yes, Your Honor.
Now, under the law, Mr. Miller, the matter of sentence is up to the judge, not to the parties. So even though it's agreed by the state and you that that should be the sentence imposed in each case, I'm not required to follow that. If you plead guilty in these cases, I could, after I considered all the information, decide to sentence you to the maximum of 54 months on the 2 charges. You understand that?
Yes, Your Honor.
And also, the matter of judicial release is up to the judge, not the parties as well. So even though there's an agreement with no opposition to be released after 6 months by the state, I'm again not required to follow that. I'll make that decision once I've seen all the information presented to me. If I decide that judicial release is not appropriate, then you may not get it. You understand that?
I do, Your Honor.
All right. Now, do you hold any license or certification from any state agency for any profession or occupation?
No, sir.
Right, now, you have certain constitutional rights you must understand before I can accept a guilty plea from you in these cases. First, you have a right in each case to have a jury trial. And that means that 12 people will be selected from a group of citizens from Highland County are summoned for jury duty on your trial day. After they were selected, those 12, the evidence will be presented. Then they will decide, after being instructed by the judge, as to the law, they would decide whether or not the state proves your guilt by proof beyond a reasonable doubt in either or both cases. And that decision or verdict would have to be unanimous, meaning all 12 of the jurors would have to agree on a verdict in each case. You understand that?
Yes, Your Honor.
All right, now, under the Constitution, you have a right to have or if you decided that you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive or give up your right to have a jury trial in writing. And waive means, in this situation, to give up. And that means that instead of a jury hearing the evidence, the judge would be the one to hear the evidence, apply the law, decide whether or not the state proved your guilt by proof beyond a reasonable doubt. You understand that?
Yes, sir.
All right, now, under the Constitution, you have rights to confront the witness against you and to cross-examine your attorney in each case. What that means is that witnesses against you, as in each case, would have to appear in open court in front of you, your attorney, and anyone else present. After the prosecutor's done asking questions of the witnesses, your attorney would ask questions. That's what cross-examination is. And that is to bring out evidence that helps your side of the case. You understand that?
I do, Your Honor.
Right now, under the Constitution, in each of these cases, you have the right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, the request the court will issue a court order that's called a subpoena. That would force those people to come to court to be available to testify for one of the two, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. Do you understand that?
Yes, Your Honor.
Right, under the Constitution, you have a privilege against self-incrimination. And what that means is that in each of these cases, you cannot be forced to take the witness stand or give evidence at any time against yourself. So no one can ever make you testify. The prosecutor can't, the judge can't, you decide. And if you decide not to testify in either of these cases, or both, the fact that you did not testify, not used against you in any way, by anyone at any time in those cases, and in fact, no one would even be allowed to talk about it in either case, except in one situation, which is if there's a jury trial, and you do not testify in either or both cases. The judge instructs the jury that because that is your constitutional right, they cannot consider it for any purpose. You understand that?
Yes, Your Honor.
Now, under the Constitution, Mr. Miller, you're presumed innocent of each of these charges until proven guilty by the state of Ohio on every essential element of the offense charged in each case by proof beyond a reasonable doubt. What that means is that the burden isn't on you to try to prove you're not guilty of either of these charges simply because you're accused. In fact, under the law, you're not required to present evidence in your own defense at either trial. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense in each case, which is the highest burden of proof that's known under the law. You understand that?
Yes, Your Honor.
Right now, originally you entered a plea of not guilty in each case. That plea denied the allegations in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described for you. Now, if you change your plea from not guilty to guilty, that is the opposite of not guilty. Guilty plea admits the allegations in each case, and admits that they constitute a crime, and admits that you committed that crime. And that plea would waive to give up in each of these two cases all of the rights that I've just described for you today, except your right to have an attorney, which you always have, no matter what your plea is going to be. But with that exception, your plea of guilty would waive to give up your right to have a jury or court trial in each case. It would waive to give up your right to confront witnesses against you and cross-examine in each case. It would waive to give up your right to use the power of the court in each case, to be able to force witnesses to come to court to testify for you, just like the state. It would waive to give up, in each case, your privilege against self-incrimination because you're the one saying you're guilty, and that's what you find for. It would also waive to give up the presumption of innocence in each case because if you say you're guilty, then the state's not required to prove that you're guilty. It also subjects you to be sentenced immediately by the court. And finally, in each case, it would waive to give up the right to file an appeal on any alleged violations of your rights that you think could have occurred up to this point in the case. Now, if I sent you to prison or the maximum sentence in prison, or under other certain circumstances, you could file an appeal. That would have to be filed within 30 days of the sentencing after you filed in that case. And do you understand all of that?
Yes, I do, Your Honor.
And are you a U.S. citizen, Mr. Miller?
Yes, I am.
All right, now, do you have any questions about the charge or possible penalties in either case?
No, sir.
You understand them?
Yes, I do.
Do you have any questions about the plea agreement in either case?
No, sir.
You understand?
I understand.
You understand there's no guarantee that you get judicial release, there's no guarantee that you'll get the sentence recommended, that I could impose a different sentence if I think it's appropriate.
Yes, Your Honor.
Do you have any questions about the constitutional rights that I've explained to you?
No, I don't.
Do you have any questions about the plea of guilty, what it means, what the consequences that would be if you enter that plea in these two cases here today?
No, sir.
You understand?
I understand.
And I don't know if I asked you, but are you a U.S. citizen?
Yes, I am.
All right, now do you have any questions that you would like to ask your attorney before we go any further?
No, sir.
Do you have any questions about anything I've explained to you this morning or this afternoon?
No, I do not, sir.
All right, then, Mr. Miller, is it your decision to withdraw your not guilty plea and plead guilty in each of these two cases pursuant to the terms of the agreement that we've just gone over?
Yes, Your Honor.
Okay, case number 21 CR 21 then, that alleges that on or about December 29, 2020, in Hyde County, Ohio, you did operate a motor vehicle as defined in ORC section 4501.01, so as willfully to elude a police officer After receiving a visible audible signal from a police officer, bring your vehicle to a stop. The operation of the vehicle by you causes substantial risk of serious physical harm to person's property. Violation section 2921.331B, the Ohio Revised Code. You charge failure to comply with order signal police officer a third-degree felony, carrying possible prison term between 9 and 36 months. In increments provided by law, and a fine of up to $10,000 and a mandatory license suspension of 3 years to life. How do you plead?
Guilty, Your Honor.
All right, then as to the charge alleges an on or about, in 21 CR 39, it alleges an on or about February 17, 2021 in this county. You did recklessly fail to appear as required in Hyden County Common Pleas Court, case number 29 CR 0021. After having been released pursuant to ORC section 2937.29, and the release was in connection with the charge of commission of felony. In violation of section 2937.99, the charge of failure to appear a fourth-degree felony, carrying possible prison term of between 6 to 18 months and a fine of $5,000. How do you plead?
Guilty, Your Honor.
All right. Court finds that on this date in open court, the defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Rule 11 in each of these 2 cases. The court orders that the plea of guilty be filed in each case, and the defendant be found guilty of the charge and indictment of each case as stated in this plea agreement. Given the nature of the offenses and the recommendation of the state and the defendant jointly, the court is not going to order pre-sentences in the court, and will proceed with sentencing forthwith. Now, anything from the state regarding sentencing?
Only what's contained in the plea agreement, Your Honor.
The $879, is that damage to a vehicle or something?
To a cruiser, yeah.
All right. Okay, Mr. Armentrout.
I would ask the court to follow the recommendation of the state that sentence Tim agreed upon, just by way of information for the court. Obviously, down the road, it's anticipated that he would file for judicial release. The original charge of thing eluding the offer from the state was going to be controlled that he failed to appear, and that changes dynamic of both cases. But the court would know what was scratched out. It was not opposed to judicial to Star, but they withdrawn that was speaking with Tim and the prosecutor. I look at the evidence in the case. It doesn't appear that Tim has a drug or alcohol problem. None of that was stated in any of the evidence. So I know the court will make that decision. You know, if you get some reports at a later time, I'm just going to make it brought to the court's attention to look at his record. Until these events, he basically didn't have much to record here on. So he just had a rough patch with his family and whatnot. And beyond that, we'd ask the court to follow the agreement at this point in time, and we'll certainly be asking the court to consider the judicial release at some point.
All right, Mr. Miller, anything you'd like to say?
No, Your Honor.
See that you weren't indicted until February of this year. Were you arrested originally on the 29th of December?
I'm not sure of the dates, Your Honor.
How long did you spend in jail before you got out at that time?
Before I found out of the indictment?
Well, you were charged in municipal court. Well, no, let me back up. This is a direct indictment. Were you ever charged, arrested, and taken to jail on this charge before your indictment?
No, sir.
Okay. So you were arrested on February the 3rd after your indictment?
No, I was arrested. I think I did like 7 or 9 days in jail. I was actually arrested in the last few days of January, and then I bonded out the first few days of February.
All right, well, we don't have any jail time credit for you. That's what I'm trying to get to.
Well, I mean, I've been in jail here for about 2 months.
Well,
That'd be unfair to appear, Your Honor.
you were released on bond in February of this year, and you were arrested on the indictment on the 2nd. And then you were picked back up, it looks like, maybe around May 17th.
I came here on the 7th of,
Of May,
yes, sir.
7th or 17th?
The 7th. I left Ross County and came to Greenfield on the 5th, and then I was there 2 days till my misdemeanor court, and then I came.
Okay, so you were in Greenfield on misdemeanor charges.
Well, I had the misdemeanor that stemmed from this right here, and then I came here, and then I went back to court that day, and I was dismissed. And
Are you serving a misdemeanor sentence right now?
no, I'm not. I'm here on this. That's the only thing I have, is what we're doing today.
Right. Well, I'm trying to figure out what your jail time credit is, and don't have anybody out there to give it to us at the moment, so I'm gonna have to just hold that up now. Because the only thing I can see in the file is you were out on February the 3rd to May the 7th here. And you say you picked up for Ross County on May the 5th. So,
No, the 17th of April was when I was arrested, and I've been incarcerated ever since.
well, where were you at? April 17th, you were in Ross County, weren't you?
Yes.
Okay. And you were arrested for something else down there?
Yeah, it was a misdemeanor charge that was,
So, and then May 5th, you were taken to Greenfield because of county court charges.
yes.
All right, so then I'm gonna say May the 7th until today, so that would be 24, 30 days in June, 1 day in July, make it 55 days. And then back in January of 2021, do you think you were arrested and served some time on this case, on this charge before you were released?
Yes, total of 7 days, I think, is what it was. No, it was no more than 9, but it was 7 to 9 days.
All right, well, we'll have to try to find that out. All right, and then I'll reserve that then. All right, then as to case number 21 CR 21. It's the judgment report of the court that the defendant be sentenced to a term of incarceration, Correctional Center for Ohio, for a period of 24 months. He'll be given credit for the jail time that he served awaiting trial in this case from May the 24th until today, which is 55 days, plus February 2nd and 3rd, which would be 1 day, 56 days, plus any additional days that the sheriff records reflect that he was in custody back in at the end of 2020 or early 2021. We'll get that from the sheriff's department. So the no fine imposed. The court is required to impose a suspension of at least 3 years, not for life. I'll impose that sentence of 3 years begin today. Now, upon the completion of this sentence, Mr. Miller, it is mandatory that you be put under post-release control supervision of the probation officer or parole officer under term set by the adult parole authority for a period of 3 full years. And if during that period of time they determine that you have failed to comply with those conditions, they can return you to prison, make you serve an additional period of up to 9 months for any one violation, up to 1/2 of your prison term for all violations. But if your violation is a new felony, then an additional whenever sentence the judge, a new case imposed by the judge can also sentence. In this case, the additional period of 1 year, whatever time left on that period, you post release control whichever is greater, that period that has to be served secondly the sentence in the case. You're also ordered to pay restitution in the amount of $879 to the village of Greenfield for damage caused to their cruiser. And if you don't, you'll be required to pay that monthly payments to the victim witness office, and they will charge, be also authorized to charge you a service fee and payment. Now, you'll also be able to pay the court costs, for which judgment is grant execution order. Fail to do that, then the court authority will do your service once you complete your prison term, not while you're in prison, but once you complete it. And you'll be given credit for each hour you work, an hour set by the court. Each hour you work will reduce your judgment by that amount, so pay the court. In case number 21 CR 39, It is ordered that you be sentenced to the Correctional Reception Center in Ohio for a period of 12 months. And that must be served consecutively with a sentence in 21 CR 21 as required by law, plus it is a separate offense and a separate course of conduct, and one single sentence without adequately reflect the seriousness of the conduct, and is a sentence that be imposed not disproportionate to the harm that's been caused. And you're also going to pay the court costs in that case. And in that case, it is optional if you get post-release control. We know you're going to get it the other one. In this case, it's optional. So we have control over the decide whether or not to be our post-release control in this case as well as in other cases. All right, we'll try to get that jail time credit. So Mr. King, when you prepare that entry, just leave that blank, and I've got a note here, and we'll build in the correct amount once we get the sheriff's certification.